In civil actions, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon a verdict, you shall have it signed and dated by your foreperson. Put back on the record on case number 21-1038. It's Odum v. Frey. The record should reflect the presence of the parties, counsel, all court personnel, and the jury. Will counsel stipulate to the correct seating of the jury?
So stipulated, Your Honor.
Yes, Your Honor.
Mr. Busby, you may call your next witness.
All right, I call Salisha.
Ms. Odum, if you'll come to the stand.
Your Honor, if I may, the parties have stipulated to the admission of photographs that have been marked as exhibits.
We just have an exhibit on that. I'm sorry.
I'm sorry.
Go ahead.
The parties have stipulated to the admission of exhibits that have been marked as 88 through 94.
88 through 94. And are those marked as admitted now, or do I need to?
Your Honor, I apologize.
That's okay.
I apologize, Your Honor. Sorry, Your Honor.
That's okay.
We should have done this before we brought the jury back. So
Do you have the versions of them on your iPad?
I do.
Could I suggest maybe you two go over to courtroom 2 and you can review them, and instead of me canvassing the jury again.
I'm sorry, Your Honor, I thought we did.
Yeah, and maybe you have, just you guys can look at them, and that way we'll just sit here if there's no objection.
Gotcha.
Your Honor, this will just take a minute. I
Yeah,
apologize.
that's fine. That's fine.
I thought we had these.
And we never went off the record, is that correct? Correct. So we still, but I'll just ask if everyone stipulate to the presence of the jury.
So stipulated.
Yes.
Your Honor, I believe that we've worked things out, so I believe that we have exhibits 88 through
88 through 94 will be admitted by stipulation, is that correct?
Yes.
They'll be admitted.
Good to see you. Have you been sworn in? Okay.
Well, I guess that's a question. She has not been sworn this time. She was previously. Let's just go ahead and administer the oath again.
Do you solemnly swear or affirm that the testimony that you're about to give in this matter, now pending before the court, shall be the truth, the whole truth, and nothing but the truth, so help you God, or under the pains and penalties of perjury?
Ms. Odom, please be seated. Go ahead, Mr. Busby.
All right, Ms. Odom. I'll try and be very quick here. So do you recall the testimony of Mr. Rush, the expert witness?
Yeah.
Okay. And he was talking about some of your vegetation, right? Okay. You wanted an opportunity to respond to some of this, is that right?
I do.
For sure. So I want you to take a look at exhibit 88 here. Do you see that?
Yes,
Can you tell the jury what that shows?
this is like 5 days before I was sprayed on July 6, 2021, and these are, the front area is tomato plants, and then right behind it is potatoes,
Okay.
and you can see they're very green.
And this has been marked as exhibit number 76. Are these the same tomatoes?
They are.
Okay. And how about 77?
Yes, same tomatoes, a week later.
All right, so let's do exhibit 89. So
Yeah,
that-
those are my potato plants.
Okay.
Yeah.
And all these pictures that I'm showing you first in sequence were taken on the same day?
They were,
Okay, why were you taking pictures that day?
because it was like a paradise out there. It was beautiful. Everything was green and producing and not a problem.
Okay. So this is exhibit 78.
Those are the potatoes after I was sprayed on July 6, 2021.
Okay, so are those the same potatoes that are shown?
They're the
This photo?
exact same potato.
Okay. Let's take a look at number 90. What are these?
Those are the squash plants, 5 days before I was sprayed on July 6, 2021.
Okay. And how about this? What does this show?
That shows the plants afterwards. after the spring.
All right, let's look at 91.
That's part
Is
of
that
my
similar?
field. Yeah, these are cantaloupe plants
Okay.
over on the side here.
Okay.
Cantaloupes, squashes.
Okay, and how about that?
Those are the same cantaloupe plants that are after the spring.
Okay. And what are these?
Squashes over here, and then I've got some melons going on over here, watermelons actually, and I believe I got carrots and, just a bunch of stuff that was beautiful.
Okay.
Probably one of the best years I was having.
Okay.
It's probably the best year.
All right. So, do you recognize this one?
I do.
What are these?
Those are the mustard plants.
Okay. And
Before the spring, 5 days.
okay.
Those
How about
are
that?
mustard after the spring.
So those are the same plants.
The exact same plants.
All right. So, is there anything you want to tell the jury before we end testimony in this case?
Objections, meeting, calls for narrative.
Overruled as the meeting. I don't know.
Go ahead, so.
I could say as far as Mr. Rush's scenarios, he hadn't been to my farm. He did not see what was going on my farm before I was sprayed. All he saw was the pictures after the spraying. And, there may have been a couple bug problems here and there, which I do a lot of hand picking of like squash bugs or whatever. But as you can see, these plants were beautiful. They were not brown, they were not curled, and they were not dying. They were producing and they were doing wonderful until I was sprayed on July 6th, 2021.
All right. Thank you. So, no further questions.
Mr. Leath?
Yeah.
Oh, yeah.
Yeah. Thank you, counsel. You stopped irrigating after the July 6th of 21 incident.
Weeks later, yes. Way after the pictures were taken
Okay.
that show the devastation on my farm.
All right. So all of the photos that we looked at yesterday,
Yes,
that we just did the comparison of before and after,
yes,
all of the photos from after then were the plants that were directly affected, according to you, from the spray of the pesticide.
yes.
Those are all the questions I have, actually. Thank you.
Anything to say?
Nothing further, Your Honor.
Thank you, sir. Mr. Busby?
No further witnesses requested.
So ladies and gentlemen of the jury, before the case may be argued to you by counsel and submitted to you for deliberation, it's necessary that the court and counsel meet outside the presence of the jury for purpose of settling the instructions that will be given to you on the law applicable to this case. We will attempt to expedite this process as much as possible. However, it is an extremely important stage of the proceeding, and both counsel and myself ask that you bear with us during this unavoidable delay. Counsel, this is what I'm thinking. I know we have some things we'll take care of this evening. I think maybe if we come here in the morning and settle jury instructions, and maybe have the jury come back in the late morning, or maybe even around 11:30. That'll give us time to do our job. You can have an early lunch, and we come back, we present it to you, first instructions, and then the argument, and then it would be submitted to you, and you'd be able to deliberate. Would that work with everyone's schedule?
Works for Thomas.
Your Honor, that makes sense. I think that's a good timeline.
Okay. So ladies and gentlemen of the jury, we're going to recess for the evening. You're admonished not to converse among yourselves or with anyone else on any subject connected with the trial. Do not communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or by other means. Do not read, watch, or listen to any news or media accounts or commentary about the case. Do not do any research, such as consulting dictionaries, using the internet, or using reference materials. Do not make any investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. Additionally, it is your duty not to form or express an opinion on any subject connected with the case until it is finally submitted to you for a decision. You're directed to return to the jury deliberation room at 11:30 tomorrow for further proceedings. Thank you. Go back on the record on case number 21-1038, Odum v. Frey. Record to reflect the presence of the parties, counsel, all court personnel, and we're now meeting outside the presence of the jury. Rebuttal testimony is concluded, and we're about to recess for the day. Is there anything we need to put on the record before we recess?
Your Honor, Carl Hebert for the defense. Will the defense 50A motion be tomorrow morning before the settling of jury instructions?
I'd prefer to do it now. If you're,
So would I.
we have an hour.
Let's do it.
Okay. Is there anything else we need to deal with today besides that? Anything for the defense? Anything else?
No, settle your instructions.
Okay.
That's it.
Are there any exhibits that have been left hanging?
I mean, there are a number that are not admitted, I think, but
About 20, 25 that are just marked.
Anything else?
that would be expected. I mean,
Yeah, I mean, if we can just take a moment
Sure.
to double check, but I believe,
we can, you want to put a copy of that updated list?
Council all have
Okay.
an updated
Okay.
list. There's been nothing that's been offered and not admitted, so everything offered has been admitted to this point.
and since 95 and 62A,
There's been no, 62A should have, on your list be,
definitive, I think we handled that one right before lunch or after
Correct.
lunch, okay.
but nothing has been done since 62.
Except for those last ones, right, where they just stipulated.
Oh, they were stipulated, offered, and admitted.
And there was nothing else offered?
No.
Okay. And I believe we have a complete list, Your Honor.
Do you agree with that, Mr. President?
I do, Your Honor.
Very well. Mr. Bear?
May I, Your Honor?
Yes.
Can I use the podium and ask Mr. Busby to remove his iPad?
It is.
Your Honor, Carl Hebert for the defendants. Is this microphone work?
So,
Your Honor, the defense makes a motion for judgment as a matter of law under NRCP 50A. We believe there are multiple legal defects and factual insufficiencies with the plaintiff's case. Let me go through the complaint claim by claim. The first cause of action or claim for relief actually is negligence, and the elements of the claim and cause of action for negligence include the defendant owed the plaintiff a duty of care, the defendants breached that duty, the breach was the legal cause of the plaintiff's injuries, and the plaintiff suffered damages. And I'm going to go ahead and cite these cases so that the board wants to look them up, they can. It's Sadler, S-A-D-L-E-R versus Pacific Care, P-A-C-I-F-I, capital C-A-R-E of Nevada, 130 Nevada 990, 995, to 2014. And my point is this: we've heard no testimony whatsoever about the standard of care here for crop dusters and how they should take care of their business. No crop duster expert came in here and said I've looked at all the records, and Mr. Frey did this wrong and he did that wrong and fell below the standard of care here and there. And this is not an area of everyday experience that a jury's going to know off the top of their head. This is not like a car accident. So there was no testimony about the breach of the standard of care, and there was no testimony that the breach of the duty was the cause of an injury. These damages were self-inflicted, at least the economic damages were. Now, let me explain. There is a Code of Federal Regulations, 205.202. And it says that this is a federal regulation, any field or farm parcel from which harvested crops are intended to be sold or represented as organic must, Part B, have had no prohibited substances applied to it for a period of 3 years immediately preceding harvest. And you heard testimony about how Salisha Odum, on at least one occasion that I thought I heard, took her crops out of production for 3 years because she thought that's what she should do.
Objection, Your Honor. That is amazing that you all make
Great,
such
then you can talk about it on your turn.
I'd like to make my objection.
Let's let it make his objection.
Your Honor, we just spent the past week trying to keep testimony about what happened in the prior incident out of the court, and the court ruled in their favor on every charge. We respectfully disagree, but it's completely improper now to try and use evidence of that situation to support the motion of rule.
Well, you may be right, Your Honor, in the sense that if I misrepresented or dragged up something from the past that I shouldn't have, then I withdraw it. But the point is this. I thought I heard that after these incidents, the three we're talking about, she withdrew her field of some production. And I think that's accurate. And we just heard that from her. She said, I stopped irrigating my crops. And she said it didn't make any sense to keep going because I didn't know what the Department of Agriculture was going to say. So I withdraw the part about 3 years. I confused that part. Anyway, I cite the court to a case called Johnson versus Paynesville, Paynesville, Farmers Union Co-op Oil Company, 817 Northwestern 2nd, 693, 711 to 712, Minnesota, 2012. And what it said is this. Under the CFR that I quoted, this court said that if the spray or the insecticide or the pesticide comes from a third party, that the grower is not required to withdraw their crops from any kind of production. It said that the regulation was aimed at producers. If the producer, that would be Mrs. Odum, puts insecticide or pesticide on her property that's not consistent with organic standards, then she would have to take her production out. She'd have to take her crops out of production for 3 years. But she doesn't have to, as a matter of law, when the contaminating chemicals come from a third party, which is what happened in this Johnsonville case. And so the court said that the damages in this case, under consideration, were self-inflicted, and as a matter of law, were not caused by the spray, which of course we dispute. So there's that case. Now, the damages were self-inflicted. There was no testimony on standard of care or breach of the standard of care. And of course, the damages were not caused by the spraying incident we deny. Next claim for relief is negligence per se. And negligence per se is not a claim for relief. Munda, M-U-N-D-A versus Summerlin, S-U-M-M-E-R-L-I-N, Life and Health Insurance Company, 12 Nevada. That doesn't look right. 267 Pacific 3rd, 771, 774, to give you a better sight. The idea behind negligence per se is that if a statute or a regulation substitutes for the standard of care, and if the defendant breaches or violates the statute or regulation, then negligence is established. If you look at the complaint, The complaint cites to NRS 555.359. We heard about that today. And this is a statute regarding restricted use pesticides, denial, suspension, revocation, and modification of the certificate. And the statute cited by the plaintiff as substituting for the standard of care, the negligence per se, is subpart 5, has made any application in a faulty, careless, or negligent manner. This is completely circular. It's not like there's a statute that says that, that applicators can't spray a school, and then Mr. Frey went ahead and sprayed a school. That would be negligence per se. What this statute says, it's negligent to be negligent. It's completely circular. This subsection 5 of 555.359 does not set a standard of care. It says you can't apply pesticides in a negligent manner, which takes us right back to negligence. So my point is, negligence per se in this case doesn't apply. Next is assault. I had difficulty finding any Nevada cases defining civil assault and civil battery for that matter, but there are a few from the District of Nevada. Estate of Salisha, SAUCEDA versus City of North Las Vegas, 380 Fed Sub 3rd, 1068, 1088 District of Nevada, 2019. To state an assault claim, a plaintiff must demonstrate that the defendant, 1, intended to cause harmful or offensive contact, and 2, the victim must put in apprehension of such contact. Number 1 was intended, and I have heard no testimony about the intent of Mr. Frey or his employee Len Weaver to deliberately cause a harmful or offensive contact or put Mrs. Odum in apprehension of that. So intent is lacking. Battery, that's the next claim for relief. To state a claim for battery, that a plaintiff must demonstrate that the defendant, 1, intended to cause harmful or offensive conduct, such conduct actually occurred. Same case, same federal case, intent is important. And again, there was no evidence of intent. Next, claim for relief is trespass. There is case law that says that particulate matter cannot be a trespass. A trespass is a tangible invasion of the right to exclusive possession of land. And a particulate matter is not such an invasion of the land. And what happened in the Johnsonville case, the site I've already given, is that somebody sprayed and drifted over on the plaintiff's land. And here it is, quote, the Johnsons assert that the cooperative trespassed when it sprayed pesticide onto a neighboring conventional field and when carried the pesticide as particulate matter onto the Johnson's land. So whether it was a deliberate act of spraying or whether it was drift from a nearby field, it's particulate. And the court in Johnson versus Painesville, said that's not trespass. And the court said, there's particulate matter everywhere. Let me quote to you from John Larkin, Inc. versus Marceau, M-A-R-C-A-U, 959 Atlantic 2nd, 551, 555, Vermont, 2008. Quote, because the ambient environment always contains particulate matter from many sources, such a technical reading of trespass would subject countless persons and entities to automatic liability for trespass, absent any demonstrated injury. Plainly, that cannot be the law. As far as we can tell, no jurisdiction is so held. The point is this: aerial spray is not trespass. It might be nuisance, which is harm to the use and enjoyment of the land, but it is not trespass. And these two cases, Larkin and Johnsonville, say that. Now, nuisance, which has been pled in this case, says that the problem with the plaintiff's nuisance claim for relief, and I'm going to quote to you from several cases, but the tort of nuisance, quote, generally arises from a continuous invasion of rights, Single incidents of objectionable conduct generally will be insufficient to establish nuisance. That's Domen, D-O-M-E-N, Holding Company versus Aronovich, A-R-A-N-O-V-I-C-H, 753 New York 2nd, 57 and 59, 2003. Quoting from a case called, can't pronounce it, NICBAO versus Two Rivers Public Charter School, 275 Atlantic 3rd, 1287, 1293-94, District of Columbia Appellate, 2022. We have required some degree of permanence such that the continuousness or recurrence of the things, facts, or acts which constitute the nuisance give rise to an unreasonable use. In that case, the court was confronted with 3 different occasions of the so-called nuisance. There's another case, I'll give you 2 more. One more. Blondell, B-L-O-N-D-E-L-L versus Courtney, Station 300 LLC, 865 Southeastern 2nd, 589601, Georgia Ave, 2021. Same holding, it has to be continuous. And just for background, the Nevada case, or one of the leading Nevada cases on nuisance and an explanation of nuisance, is Sowers, S-O-W-E-R-S versus Forest Hills Subdivision, 129 Nevada 99, 104, 2013. Nevada has no cases on the continuous nature of nuisance, but that requirement is found in many other states. The next cause of action is conversion. Now, conversion is the exercise of, it's a wrongful exercise of an act of dominion over personal property, and that's the problem here. You can't convert real property. You can only convert personal property or chattel. Well, what got converted here? If the jury accepts that there was a conversion, pesticide was only found on 1 pepper plant. The court heard plenty of testimony about that. So the conversion was the damage to 1 pepper plant. And remember that Mrs. Odums gave up on her organic gardening after these spring events. So what did the Nevada courts say? In Edwards versus Emperor's Garden Restaurant, 122 Nevada 317, and M.C. Multi-Family Development, LLC, 124 Nevada 901, talking about conversion, the Emperor's Garden case involved an unsolicited telefax from a Chinese restaurant. And a Chinese restaurant was sued by Mr. Edwards over this unsolicited communication, and he wanted some fines under the Federal Telecommunications Act. And he claimed conversion, and he claimed that they converted his paper and his ink on his fax machine. And the court said, the Nevada Supreme Court in Emperor's Garden said, conversion generally is limited to those severe, major, and important interferences with the right to control personal property that justify requiring the actor to pay the property's value in full. I went on to explain the doctrine of de minimis and said the law does not concern itself with trifles, and Edwards' conversion claim is a trifle, just like a pepper plant would be. So the court does not have to recognize as a matter of law the conversion of 1 pepper plant. And finally, we get to punitive damages. And NRS 42.005 says that the plaintiff has to prove by clear and convincing evidence the defendant has been guilty of oppression, fraud, or malice. I've heard nothing that rises to the level of clear and convincing evidence in this case that the defendants consciously disregarded the rights of Mrs. Odum. Maybe, there's a big question of, I suppose there's a question of fact here on whether or not the defendants deliberately sprayed the property. We claim that they didn't, and you heard that testimony. But this is not evidence rising to the level of punitive damages. And the court, as a matter of law, can withdraw the issue of punitive damages before it ever gets to the jury, and that is Jeffers versus Bob Kaufman, K-A-U-F-M-A-N Machinery, 101 Nevada 684, 1985. Where the court says, finally turning to the Droges' claim for punitive damages, We note that punitive damage is a remedy, not a cause of action. We believe the district court could reasonably have concluded that evidence of malice in fact had not been presented by the parties. The court, as a matter of law, can withhold punitive damages from the jury. It doesn't have to go there. The court acts as a gatekeeper under these circumstances. And finally, this is an aside, punitive damages are not a claim for relief. They're a remedy. Droge, D-R-O-G-E versus Quadruple A, two-star towing, 136 Nevada 291. And for all those reasons, Your Honor, we move for judgment as a matter of law on each of the claims for relief.
Mr. Busby.
Thank you. All right. I'm going to run through the evidence in the case. Insofar as there's a lot of citations in cases that were entirely outside of the jurisdiction of Nevada. There's no indication that any of these standards have been actually adopted by Nevada courts. Firstly, the negligence claim. The duty of care is obviously the ordinary duty to avoid the risk of harming others or causing harm. There was no argument that the defendants could do what they were doing with their claims, and that doing so in a faulty, careless, or negligent manner didn't constitute negligence. They breached that duty by flying their planes too close to my client's property and by spraying her with pesticides, burning the property. The causation of the damages is evident. A reasonable jury can infer from the facts presented that, including the positive pesticide test as well as the physical evidence of the plants dying, that the causation was there, and damages, my client testified at length about not only the destruction of her crops, but the interruption of her business for extended period of time as a result of the spraying incidences. And negligence per se, basically, I'm not sure how, that's not a claim, it's in jury instructions. We have established that the duty created by statute under NRS 555-350 sub 1 makes it unlawful to apply pesticides in a faulty, careless, or negligent manner. Mr. Hebert only mentioned negligence, but it also makes unlawful the faulty, careless, or careless application of pesticides, and establishes a duty upon which the plaintiff's negligence claim can be based, because she's the type of party that statute is intended to protect. Now, basically, the defendant's position was, we didn't do anything wrong, that we didn't spray her property, and that we never flew in a faulty, careless, or negligent manner. There's never been a denial of the duty to prevent, to not engage in such conduct in the first place. As for the assault claim, there's been clear evidence that Ms. Odum was afraid of harmful or offensive touching from the plane. She testified to that, and that she reasonably believed she was about to be touched or was touched by, the spray from the planes. And this is the kind of touching that would offend a reasonable person's sense of dignity, in the insult context, even if it doesn't happen, and in the context of a battery, when it does happen, as it did in this case. It's clear that Odum didn't consent to the touching. She filed complaints with the Department of Agriculture. They knew that she was doing organic farming. They sprayed her anyway. They flew past her property anyway. The intention element of these offenses can be inferred from the conduct of the party. No party says in their testimony that I actually intended to do this, but their conduct renders a situation where a reasonable jury can make such a finding. For example, Mr. Frey just testified that he told Mr. Weaver to stay away from my client's property as he was flying. He didn't do so on 2 occasions. And on the 3rd occasion, that's the subject of the suit, Mr. Frey flew over my client's property himself. Trespass is the physical invasion of real property. And that happened in 2 manners in this case, not just one. One was the plane, the other was the spray from the pesticides. Now, trespass is the interference with a proprietor's right to exclusive possession of property. And all we have to prove a trespass is intentional physical invasion. Now, they had control over the planes. There was no testimony that there was some kind of inadvertent flying over the property. There's been lots of evidence that they did indeed fly over the property in terms of videos and the testimony of witnesses such as Ms. Odum, her daughter, Mr. Rakoff, and Annette Anderson. Nuisance, okay. Nuisance is the substantial and unreasonable interference with the use and enjoyment of property. Okay. In this context, the interference was the flying over her property and spraying with it with pesticides. And that interfered with her free use of the property such that she couldn't comfortably enjoy her life on it. Her whole purpose for owning this property is to run her farm so she can feed herself and her family and make a living. And that purpose was substantially and unreasonably interfered with when Mr. Frey continually flied over her property. And Mr. Frey and his company continually flied over the property and sprayed it with pesticides. Now, intention in the context of nuisance is established where the nuisance is the natural and ordinary consequence of someone's actions. Now, once again, there was knowledge of an organic farm, multiple flyovers and spraying events. A reasonable jury could infer from those facts that there was indeed an intention to cause a nuisance in this situation. And any normal person living in the community, I think, would regard getting sprayed by pesticides as definitively offensive, seriously annoying, or intolerable. And the gravity of the harm to Ms. Odum outweighs any social value that the activity alleged to cause the harm has. And there's no reason why she needs to be sprayed with pesticides. As Mr. Weaver testified, there was a method they could have used to spray the neighboring field that would have prevented them from flying over or near her property. They just didn't want to do that because it was more expensive. Now, there's also been a claim that NRS 40/140 insulates a party from liability because there's a presumption that an agricultural activity conducted on farmland consistent with good agricultural practice is reasonable, and that such activity does not constitute a nuisance unless it has substantial adverse effects on public health or safety. And there's been allegations here that Ms. Odum was battered, she was assaulted, there's public safety issues. There's also allegations she was sprayed with pesticides. That's a safety issue and a health issue. The spraying of an organic farm of food that people might eat, that's another health and safety issue. And spraying an organic farm that you know exists is not consistent with good agricultural practice. Further, the statute should also protect Ms. Odum's interests, which are, she has the right to engage in traditional farming and use her properties as she sees fit. Conversion, okay. Conversion is basically the distinct act of dominion wrongfully exerted over another's personal property in denial or inconsistent with the title rights therein. And it's essentially where you exercise dominion and control over personal property. And in this case, the evidence shows that by continually flying over Ms. Odum's property and spraying her property with pesticides, they were exercising dominion and control over her plants, which are her personal property. That being the case, a reasonable jury could find that conversion occurred. And also, conversion doesn't require proof of wrongful intent. It's not excused by care, good faith, or lack of knowledge. It's just enough that the defendants intended to take the act that caused the interference with the plaintiff's property, i.e. flying over. We've also alleged vicarious liability in this context. Frey Spray is clearly responsible for the activities of its agent, Mr. Weaver. He indicated in his testimony that he was acting within the course and scope of his duties with Frey Spray. On the exemplary damages claim, we have to show by clear and convincing evidence that the defendants were guilty of oppression and or malice. And to prove that, we need to show that they engaged in conduct which is intended to injure a person or despicable conduct which is engaged in with a conscious disregard for the rights or safety of others. Now, the videos of Mr. Frey flying over my client's property, despite, this was the last incident that's issued, despite her numerous complaints, despite the NDA telling him to stay away from her property, despite him telling his own employees to stay away from the property, and with full knowledge that this could basically wipe out her business for an extended period of time if she sprayed pesticides. So Mr. Frey knows all these things, but he still continues to do it. That is a conscious disregard for Ms. Odom's right to make a living as a farmer, and it's a conscious disregard for her safety, because there's spraying her with chemicals which are objectively, dangerous, and that the pesticide that's at issue in this case, where a positive test was found on my client's property, has now been banned from human consumption or application to food products. And the oppression element of exemplary damage is also met because despicable conduct that engages a person to cruel and unjust hardship with a conscious disregard of rights is oppression. Now, in this case, Mr. Frey had complete knowledge that Ms. Odum was an organic farmer. Again, he knew of the consequences to her if there was a positive test on the property. He also knew how this affected her, not just physically and economically, but psychically. It's a terrifying thing to have a plane continually flying over your property, and it's especially terrifying when the consequences of that plane, like Ms. Odum described in her testimony, was to dash months and months and months and months of work and put you in a situation where you lose the means to feed your family. And a conscious disregard means knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to avoid these consequences. Now, once again, Mr. Frey and Mr. Weaver knew very well exactly how to spray neighboring fields in such a manner that they never would have to come close to Ms. Odom's property. And they simply chose not to do so for presumably economic purposes, despite her numerous complaints to the NDA, despite the warnings to the NDA, despite the investigations, despite everything that occurred before. And with that, I'd be glad to answer any questions the court has. We believe the evidence shows that there are genuine issues of material fact on every element of the plaintiff's claims, and that it's improper to dismiss any of them at this time without a determination from the jury.
Thank you.
Your Honor, the plaintiff would have you believe that the act infers the intent or implies the intent. Mr. Frey, trying to be a good neighbor, as the Nevada Department of Agriculture suggested in each of its findings, each of its negative findings, told Mr. Weaver to try to stay away from Salisha Odom's property. That militates against intent and against conscious disregard of her rights. He's trying to be a good neighbor. He told his employee to stay away from her property if you could do it. But I also point out to the court that the airspace above Salisha Odom's farm is not restricted. Planes can fly above her property. She doesn't own the airspace. And it's hard to believe that she lives in an agricultural area in West Fallon, and yet she's terrified of crop dusting. Crop dusting happens all the time out there. That's how these farmers make their living. So her sense of outrage and her sense of terror is highly exaggerated. Anyway, Your Honor, we'll submit our motion under 58.
Thank you, counsel. I am going to go over this this evening. What I think we should do is probably come back at 9 tomorrow. I'll rule on the motion, because I think we need to have a ruling on the motion before we settle jury instructions. And then what I'd like to do is give counsel a chance to meet together, see what you can agree on, and then we can meet and finalize, and if there are any objections to what the court proposes as jury instructions, we can put that on the record. So we'll be back here essentially at 9. We'll go on the record. I'll rule on the Rule 50 motion. And then we'll give counsel time to see what they agree on. We'll then settle instructions. I don't think that'll take us anywhere close to 11:30, so there are a little bit of time to work on the closing arguments. We'll instruct the jury in closing arguments and submit the case to the jury. Does counsel want the jury to be instructed before argument?
Your Honor, I do prefer that.
That's my general practice, but I want to just make sure.
Your Honor, yeah, we prefer instructing before.
And that's, I just always like to ask in case somebody has a strong feeling, that's my general practice. So we'll instruct them, we'll bring up closing arguments, and we'll send it to the jury. So we'll be in recess till 9 a.m. tomorrow.
All rise.
Good morning. This is case number 21-1038, Salisha Odum versus Jerry Frey. The record will now reflect the presence of the parties, counsel, all officers of the court. We're meeting outside the presence of the jury. The court's rule on the 50A motion that was orally made and orally opposed yesterday at the conclusion of the presentation of the evidence to the jury. The court has had a chance to review, and Mr. Hebert did indicate that it was going to be a fairly lengthy motion, and it was. There was a lot of interesting cases cited, and the court's had a chance to review those. The controlling law in this case is Nevada Rule of Civil Procedure 50A, which applies the following evidentiary standards. The party has been fully heard on the issue, in this case during the jury trial, and the court finds that a reasonable jury would not have legally sufficient evidentiary basis to find for the party on that issue. The court may resolve the issue against the party and grant a motion for judgment as a matter of law. That is the standard the court is required to apply, and the court will apply. I have considered the evidence that's been presented and what is necessary to be proved if that evidence were to be accepted by the trier of fact, who in this case is the jury. Applying that standard to these issues that are before the court does find that all of the causes of action stated by the plaintiff will proceed to the jury. And as to the question of punitive damages, I am going to allow an instruction to the jury on whether those should be awarded at a subsequent hearing. And so that's my ruling on the 58 motion. Anything from you, Mr. Ruskin? Mr. Hebert?
To summarize, Your Honor, it was denied in its entirety.
That's correct. It's pretty, the standard is what it is, and I think that there's a preference for the jury who has heard the evidence. If there is some evidence that, if believed, and that's what the court has concluded, there was evidence that was presented that, if believed, would support those causes of action. So as far as jury instructions, does counsel want to meet together first, or do we want to meet together and just settle them together?
Your Honor, I would defer to the court on the issue if you've got other matters you need to deal with.
I could use a few minutes to sign a few documents, but I don't want you to waste your time. If you think there's something you can agree on, and then we can. Mr. Leath, what are your thoughts?
Your Honor, I think that if we can give counsel an opportunity, perhaps we can come to agreement on certain ones. What are the issues, if any?
And then what I would suggest is you do have you have courtroom 2. How's courtroom 2 set up?
Like a courtroom.
So there's a jury room in there if you want just a little more space to spread out, and you can go in there and do that, and then just let me know, and I can come on over whenever you're ready. We can go over them there, and then we come back here on the record and settle them. Anyone has any objections, we'll put those objections on the record after that.
Okay, thank you, Your Honor.
Thank you.
All rise. All rise.
Please be seated. Good morning. We're back on the record. I guess it's maybe good afternoon now. On case number 21-103, Odum v. Frey. We're meeting, all parties are present, counsel's present, court personnel are present. We're meeting outside the presence of the jury for the purpose of settling jury instructions and the verdict forms. So the court has the proposed, and I appreciate all the work that council put in this morning to get these finalized. Jury instructions 1 through 32 that the court proposes to give to the jury. Mr. Busby, do you have copies of that?
I do, thank you.
And Mr. Leath?
Yes, thank you, Your Honor.
Does the plaintiff wish to object to any of the instructions that the court proposes to give?
Yes, Your Honor. I'd like to instruct, sorry, just a second.
That's
I
okay.
didn't find the instruction. Instruction number 14, Your Honor. Recently, the Supreme Court issued a decision in Cedar Point Nursery versus Hassid. And that's at 141 Supreme Court 2063, 2021. And that decision essentially states that through regulation, a government can't compel a private party to countenance a physical invasion of the property because it constitutes inverse condemnation, a physical per se taking under the law. We believe insofar as this statute could be interpreted to permit that and to undermine a nuisance claim on that basis, we believe that interpretation of the statute would constitute a taking of the United States Constitution.
And just so I'm clear, jury instruction 14 is based on a Nevada revised statute.
It is, Your Honor. It's Nevada Revised Statute 40.140.
And you're not objecting that this doesn't comply with that, you're objecting that it's not consistent with the United States Constitution.
Correct, Your Honor. I'm objecting to the substance of the law itself.
Very well. Your objections, any other objections? Mr. Hebert or Mr. Leath?
Your Honor, may I address the court while seated?
Of course.
Your Honor, the defendants object to several jury instructions, the first of which is number 5. For the reasons stated in the defendant's 50A motion for judgment as a matter of law, they object to giving any instructions on the claims for relief listed in instruction number 5, which I will then go over as the instructions arise. And the first of those, we object to instruction number 6 on the basis of negligence. We object that there was no testimony about the standard of care for crowd dusters. There was no testimony in the breach of the standard of care, and there was no testimony that the breach of the duty was the cause of an injury. And I cite the court to Johnson versus Paynesville Farmers Union Co-op, 817 Northwestern 2nd, 673, 711-12, Minnesota 2012. Further, there were no damages. Let me rephrase that. The damages were self-inflicted. 7 Code of Federal Regulations, section 205.202, B parens, only requires a producer who has applied prohibited insecticides to an organic land take the crop out of production. And if there was an application of prohibited substances on the property, it wasn't by Salisha Odum. Therefore, she was not required to take her crops out of production at any stage. And therefore, the spraying, if it happened, was not the cause of the injury. And that would be the loss of her crops. Moving on to number 7 is objected to on the general basis that we object to the giving of any instructions on negligence at all, the reasons just stated. Number 8, we object to this instruction for the same reason as 6 and 7, and including that the spraying, if it happened, was not the proximate cause of her economic damages, and that's the Johnson case, again, 817 Northwestern 2nd, 693. On number 9, which is a negligence per se instruction, this instruction does not state any kind of statutory standard which could have been breached to form the standard of care for negligence per se. It's circular. The statute cited simply says you can't apply pesticides in a negligent manner. And when read with the other instructions, it basically says you can't be negligent by being negligent. Instruction number 10 is the assault instruction. And we object to this instruction because we heard no evidence of intent by Mr. Frey or Mr. Weaver to cause harmful or offensive physical contact. No intent. And therefore, this instruction should not be given.
Mr. Mayor, can I just interrupt you right there? I just want to stop for a second. Mr. Busby and Mr. Hebert and Mr. Leath, I was looking at the verdict form, and I want to make sure what we talked about on page 2. We talked about adding the preponderance of the evidence in questions 1 through 7. And then on the exemplary damage, I thought we were going to put clear and convincing in that. We were going to prepare that.
Sorry.
And so I was, as Mr. Hebert is making a record, if we could email that to him, and we could reprint that. If that was my recollection, just to save some time.
My court's absolutely correct.
My apologies.
That's okay. That way we can replace that. Go ahead, Mr. Hebert.
Instruction number 10 on assault, I just covered it. There was no evidence of intent on the part of Mr. Weaver or Mr. Frey. Instruction 11, which is battery. Again, there was no evidence of intent to cause harmful or offensive contact on the part of Mr. Weaver or Mr. Frey. 12 is trespass instruction. This should not be given because, as a matter of law, aerial particulate matter cannot be a trespass. And I cite the court to Larkin versus Marceau, 959 Atlantic 2nd 551, 2008, Vermont. And the Johnson case again, 817 Northwestern 2nd 693, Minnesota. Next is instruction number 13. We object to the giving of this instruction because the conduct proven at trial was not a nuisance because it was not continuous or a recurrence on a regular basis. The whole idea of nuisance is a continuous or regularly repetitious act or condition which causes hurt, inconvenience, or injury. The defendant sent the court to Doman Holding Company, 753 New York sub 2nd 57, New York 2003. Nick Deo, NICDAO, 275 Atlantic 3rd 1287, District of Columbia Court of Appeals, 2022. And Blondell, 865 Southeastern 2nd 589, Georgia, appellate 2021. Instruction number 14. We're not objecting. 15 is conversion. The defendants object to the giving of this instruction on the basis that, first, real property cannot be converted. Second, if there was any conversion, the proof is that one pepper plant had some level way below the minimum of chlorpyrifos. And if one pepper plant was converted, that is de minimis under a Nevada case called Edwards versus Emperor's Garden Restaurant, 122 Nevada 317, 2006. And a temporary interference of the property right is not sufficient. And that's Waterfall Farm Systems, Inc., 914 Fed Sub 1213, District of Maryland, 1995. The defendants object to the giving of instruction number 17, which is a exemplary or punitive damages instruction. There was no evidence by a clear and convincing nature or any other burden that the defendants or Mr. Frey or Mr. Weaver acted maliciously or oppressively or with conscious disregard for the rights of Mrs. Odum. You're engaged in good agricultural practices in spraying nearby agricultural land, and she has no right to the airspace. There's no restricted airspace above her house. Number 18 is the same objection. There was no evidence. There's no evidence of punitive conduct by clear and convincing standard, and therefore it's not necessary to give a vicarious liability instruction that the employer can be liable for the conduct of the employees. And then the employer would be Frey Spray LLC, and the employees would be Jerry Frey and Lynn Weaver. Let me go through these for a moment, Your Honor. We objected to giving instruction number 31 on the basis that there was no trespass, that airborne particulate matter cannot be a trespass, and it's not a trespass to fly an airplane above, in the airspace above someone's house. There was no evidence that the airspace was restricted by FAA regulation or statute, or local regulation or statute. And the special verdict form is objected to on the basis that none of the causes of actions are supported by the evidence or are prohibited as a matter of law. And then, finally, those are the objections of the defendants to the instructions that the court intends to give. The defendants would also propose one instruction which the court.
We'll get there.
Got it.
So I've noted Mr. Busby's objection, and I've also noted Mr. Hebert's objection. I'm going to ask you the same question I have Mr. Busby, though, Mr. Hebert. The instructions that we're going to give or propose to give, your objection isn't as to the substance, if it were applicable to whatever cause of action, right? It's there.
If the cause of action, if the evidence supported these causes of action, then the instructions given accurately state the law.
And that was my question. I wanted to make sure I understood that right. And so, does the plaintiff, Mr. Busby, wish to offer any instructions in addition to the proposed instructions by the court?
The plaintiff does, Your Honor.
Which one?
Would you like me to read the instructions into the record?
Yes, please.
We'd like to request that the court provide instruction based on Nevada Jury Instruction 2018 2.9. Before trial, each party has the right to ask other parties to answer written questions. These questions are called interrogatories. The answers to the interrogatories are also in writing and are sworn under oath. You must consider the questions and answers that were read to you the same as the questions and answers of the court. I'm sorry, that's right.
Yeah, I think we gave that one.
Yes. I withdraw that request, Your Honor. This request, which I do want to, I can't believe I read the whole thing without doing it. This is Nevada Jury Instruction 2018 2.4. It states, where relevant evidence which will be properly in part of this litigation is within the control of one party who's interested in naturally produce it, and they fail to do so without satisfactory explanation, the jury may draw an inference that such evidence would have been unfavorable to that party. The same can be inferred from improperly altered evidence. An inference means a logical and reasonable conclusion of a fact not presented by direct evidence, but which, by process of logic and reasoning, the jury may conclude exists from the established facts.
Would you be able to provide that to the court?
May I approach you?
Of course. You can make any argument you want from that.
Okay.
And I will note that we'll mark this as an exhibit, and in the court's exhibit 1. And I do note that it does have the citation on it. This will not go to the jury if I don't get it. I just want to, so the record's clear. But go ahead, Mr. President.
Your Honor, for the record, we believe the evidence shows that certain evidence that would have been in the normal course of things presented in this case was destroyed by the defendants, namely the GPS data from the planes. And there was an indication that those records are routinely destroyed in flight. but that they could also be preserved and have been preserved in other instances. Also, there's no doubt that the defendants were aware of the potential for litigation arising out of the complaints that were made by the plaintiffs in this matter. There was previous litigation between the parties, which was settled. There was a August 31st, 2020 complaint, and at a minimum, at that time, they were on notice of the potential for litigation given the allegations made by Ms. Odum to the Nevada Department of Agriculture. That should have triggered the duty to preserve all relevant evidence, including Bass v. Bass Davis, the case that provided the reasonable notice of litigation is sufficient to trigger the duty to do so.
Thank you.
Thank you, Your Honor.
Thank you. And, we'll mark this as court's exhibit 1, and I've signed it, I've written on it, authored by plaintiff, not given and signed it. Ms. Polk, would you check with Ms.
She has them, she was just waiting for my key.
Okay, let's go ahead and get them, just so we have them. And, any other instructions?
No, Your Honor, I'm going to wait.
Mr. Adair?
Yes, Your Honor, one instruction. May I approach?
Yes.
Your Honor, this is similar to jury instruction number 14, but not exactly the same. It's the good agricultural practices instruction based on the Churchill County ordinance. We think it fits the facts here. There's been no proof that, Mr. Frey, I want to state this correctly. I don't think there was any proof that Mr. Frey violated good agricultural practices in doing what he testified that he did.
Thank you. Ms. Clerk, I'll handle this proposed exhibit and mark it as court's exhibit 2. We signed it and noted that it was offered by defense and was not given as court. So what we have now, other than the plaintiff's proposed that the court will not give, and the defense's proposed that the court will not give, we have instructions 1 through 32 that the court will give to the jury. Will counsel stipulate that the instructions that 1 through 32 that I'm prepared to give to the jury have been settled in open court?
So stipulated.
Yes, Your Honor.
Yes, Your Honor.
And now we have the special verdict form that I think we just was handed to each of you. And this was agreed upon by both sides, I believe. And does everybody agree that this will be the verdict form that we'll send in to the jury?
Plaintiff doesn't.
The references to the plaintiff's proposed jury verdict form.
Yes, yes,
Yes.
Yeah.
The question was, do we agree that this is the one that will go to the jury?
yeah,
The answer is yes.
okay.
Yes, Your Honor.
With the objection, of course, that it shouldn't go there at all, but
Sure.
having said that, yes.
Okay. And we've agreed that we'll instruct the jury prior to argument.
Yes.
Yes, sir.
So how long do you, I want to be reasonable to each counsel, how long do you need before we bring the jury in and instruct them and do closing arguments, start closing arguments?
There's always more that can be done, Your Honor, but I'm ready if you are.
Okay, Mr. Lee?
Yes, I'm ready, Your Honor.
Okay.
I mean, I would assume I'll probably have to take a break between Mr. Busby's and mine
Sure.
to reposition the
Sure.
podium, et cetera, but
Sure.
yeah.
Does anybody need just a brief recess and we'll bring them in? We'll be here for a while. Why don't we take just, I mean, they'll let me know when everyone's had a chance to take a comfort break. When you're back here, we'll bring the jury in, I'll come out and we'll instruct the jury.
Thank you, Your Honor.
We'll be in recess.
All rise.
Please be seated. Put back on the record on case number 21-1038, Odum v. Frey. The record should reflect the presence of counsel, both parties, all court personnel, and the jury. Will counsel stipulate for the correct seating of the jury?
So stipulated, Your Honor.
Yes, Your Honor.
Ladies and gentlemen of the jury, thank you for your patience. Sometimes we estimate how long our business is going to take, and it takes us a little bit longer, but I want to assure you, when you were waiting on us, it wasn't because we weren't working. We were working diligently, so thank you for that. I'm about to instruct you upon the law as it applies to this case. I would like to instruct you orally without reading to you. However, these instructions are of such importance that almost every word is of some significance. Therefore, it is necessary for me to read to you from carefully prepared written instructions. The instructions are relatively long and some are quite complicated. If they are not especially clear to you when I read them, please bear in mind that you will be provided a copy of the instructions when you retire to the jury room so that you can read and consider them. Members of the jury, it is now my duty as a judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and apply the rules of law to the facts as you find from the evidence. You find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that is given in these instructions. Instruction number 1, although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Number 2, if during this trial I have said or done anything which has suggested to you that I am inclined to favor the claims or the position of any party, you will not be influenced by any such suggestion. I have not expressed nor intended to express, nor have I intended to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inference should be drawn from the evidence. If any expression of mine has seemed to indicate an opinion relating to any of these matters, I instruct you to disregard it. Number 3, you must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or law, or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works for additional information. Instruction number 4. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. And this we try to make these gender neutral, and it says his, but I'm just gonna say that they were both female and male witnesses. I'm not trying to infer anything. Counsel, I just want to make that observation. Is that fair?
No objection, Your Honor.
Yeah, no objection, Your Honor. Thank you.
Instruction number 5. Plaintiff Salisha Odum has brought the following claims against the defendants: negligence, negligence per se, assault, battery, trespass, nuisance, conversion, and for exemplary damages. I will now instruct you on each of these claims. Instruction number 6. To prevail on a negligence claim, the plaintiff must establish that 1. The defendants owed the plaintiff a duty of care. 2. The defendants breached that duty. 3. The breach was the legal cause of the plaintiff's injuries. And 4. The plaintiff suffered damages. Instruction number 7. Generally, everyone has a duty to exercise reasonable care when their conduct creates a risk of physical harm to others. Negligence is the failure to exercise that degree of care which an ordinary, careful, and prudent person would exercise under the same or similar circumstances. Ordinary care is that care which persons of ordinary prudence exercise in the management of their own affairs in order to avoid injury to themselves or to others. You will note that the person whose conduct we set up as a standard is not the extraordinarily cautious individual, not the exceptionally skillful one, but a person of reasonable and ordinary prudence. While exceptional skill is to be admired and encouraged, the law does not demand it as a general standard of conduct. Instruction number 8. Approximate cause of injury, damage, or loss or harm is a cause which, in natural and continuous sequence, produces the injury, damage, loss, or harm, and without which the injury, damage, loss, or harm would not have occurred. Instruction number 9. There was in force at the time of the occurrence in question NRS 555.350, subsection 1, subsection E, making it unlawful to apply pesticides in a faulty, careless, or negligent manner. A violation of this law constitutes negligence as a matter of law. If you find that a party violated a law just read to you, it is your duty to find such violation to be negligence. And you should then consider the issue of whether that negligence was the cause of injury or damage to the plaintiff. Instruction number 10. Odum claims that the defendants assaulted her. To establish this claim, Odum must prove all of the following. 1. That the defendants acted intending to cause harmful or offensive contact. 2. That Odum reasonably believed that she was about to be touched in a harmful or offensive manner. And a touching is offensive if it offends a reasonable sense of personal dignity. Instruction number 11. The plaintiff claims that the defendants committed a battery. To establish this claim, Odum must prove all of the following. 1. That the defendants touched Odum with the intent to harm or offend Odum. 2. That Odum did not consent to the touching. 3. That Odum was harmed or offended by the defendant's conduct. And 4. That a reasonable person in Odum's situation would have been offended by the touching. Instruction number 12. Plaintiff claims that the defendants trespassed on her property. To establish this claim, the plaintiff must prove by a preponderance of the evidence that the defendants substantially caused an unjustified invasion of a plaintiff's real property, and that the invasion caused damages to the plaintiff. Instruction number 13. The plaintiff claims that the defendants created a nuisance on her property. To prevail on this claim, the plaintiff must show by a preponderance of the evidence that the defendants created the situation that is injurious to health, or indecent and offensive to the senses or interfered with the comfortable enjoyment of plaintiff's life or property. Instruction number 14. It is presumed by Nevada law, A, that an agricultural activity conducted on farmland consistent with good agricultural practice and established before surrounding non-agricultural activities is reasonable. Such activity does not constitute a nuisance unless the activity has a substantial adverse effect on the public health or safety. B, that an agricultural activity which does not violate a federal, state, or local law, ordinance, or regulation constitutes good agricultural practice. Instruction number 15. The plaintiff claims that the defendants converted her personal property. To prevail on this claim, the plaintiff must show that the defendants wrongfully exerted dominion or control over the plaintiff's personal property in denial of or inconsistent with their right or rights therein, or in derogation, exclusion, or defiance of such title or rights. Conversion does not require proof of wrongful intent and is not excused by care, good faith, or lack of knowledge. Instruction number 16. In this case, Lynn Weaver was the employee of Frey LLC. If you find that Lynn Weaver was acting within the scope of his employment when the incident occurred, then Frey LLC is responsible for any harm caused by Lynn Weaver. Instruction number 17. If you find that the plaintiff suffered damage because of the defendant's conduct and that the defendants are liable based on that conduct, you may then consider whether you should award punitive or exemplary damages against defendant Jerry Frey and Frey LLC. Punitive or exemplary damages are to make an example of or punish wrongful conduct. You have discretion to award such damages only if you find by clear and convincing evidence that the defendant was guilty of oppression and or malice in the conduct providing your basis for liability. Malice means conduct which is intended to injure a person, or despicable conduct which is engaged in with a conscious disregard of the rights or safety of others. Oppression means despicable conduct that subjects a person to cruel and unjust hardship with conscious disregard of the rights of that person. Conscious disregard means knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to avoid these consequences. The law provides no fixed standards as to the amount of such punitive damages, but leaves the amount to the jury's sound discretion, exercised without passion or prejudice. In arriving at any award of punitive damages, you are to consider the following: the responsibility of the conduct of the defendant. 2, the amount of punitive damages which will serve the purposes of punishment and deterrence, taking into account the defendant's financial condition. Instruction number 18. You may consider awarding punitive damages against an employer for the wrongful conduct of its employee only if the employer had advanced knowledge that the employee was unfit for the purposes of the employment and employed him with a conscious disregard of the rights or safety of others, or the employer expressly authorized or ratified the wrongful act of the employee for which the damages are awarded, or the employer is personally guilty of oppression, fraud, or malice under the instructions I have given you. If the employer is a corporation, these requirements must be met by an officer, director, or managing agent of the corporation who is expressly authorized to direct or ratify the employee's conduct on behalf of the corporation. A managing agent is a person who exercises substantial independent authority, discretion, and judgment in his corporate decision-making so that his decisions ultimately determine corporate policy. Instruction number 19. When you retire to consider your verdict, you must select one of your number to act as foreperson, who will preside over your deliberations and will be your spokesman Once again, we didn't catch a gender thing. We generally say spokesperson, but it says spokesman here in court. During your deliberations, you will have all the exhibits which were admitted into evidence, those written instructions and forms of verdict, which have been prepared for your convenience. In civil actions, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon a verdict, you shall have it signed and dated by your foreperson, and then return it to this room. Instruction number 20. In determining whether any proposition has been proved, you should consider all the evidence bearing upon the question without regard to which party produced it. Instruction number 21. Plaintiff has the burden of proving by a preponderance of the evidence all the facts necessary to establish all of her claims. A preponderance of the evidence means such evidence as, when considered and weighed against that opposed to it, has more convincing force and produces in your mind a belief that what is sought to be proved is more probably true than not true. Plaintiff has the burden of proving liability for punitive damages by clear and convincing evidence. Clear and convincing evidence is that measure or degree of proof which will produce in your mind a firm belief or conviction as to the allegations sought to be established. It is an immediate degree of proof, being more than a mere preponderance, but not to the extent of such certainty as is required to prove an issue beyond reasonable doubt. Proof by clear and convincing evidence is proof which persuades you that the truth of the contentions is highly likely. In determining whether a party has met this burden, you will consider all the evidence, whether introduced by the plaintiff or the defendant. Instruction number 22. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are 2 types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what the witness personally saw or heard or did. Circumstantial evidence is proof of one or more facts from which you could find another fact. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in this case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate, meaning to agree, to the existence of a fact, you must accept the stipulation of evidence and regard that fact as proved. Questions are not evidence, only the answer is evidence. You should consider a question only if it helps you understand the witness's answer. Do not assume that something is true just because a question suggests that it is. You must also disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence. You must also be disregarded. Instruction number 23. Before trial, each party has the right to ask the other parties to answer written questions. These questions are called interrogatories. The answers to the interrogatories are also in writing and are sworn to under oath. You must consider the questions and the answers that were read to you the same as if the questions and answers have been given in court. Instruction number 24. The lawyers have shown you charts and summaries to help explain the facts. The charts or summaries themselves, however, are not evidence or proof of any facts. Charts and summaries are only as good as the underlying evidence that supports them. You should therefore give them only such weight as you think the underlying evidence deserves. Instruction number 25. An attorney has a right to interview a witness for the purpose of learning what testimony the witness will give. The fact that the witness has talked to an attorney and told that attorney what he or she would testify to does not reflect adversely on the truth of the testimony of the witness. Instruction number 26. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his or her opinion as to any matter in which he or she is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such opinion. Give it the weight to which you deem it is entitled, whether that be great or slight, and you may reject it if, in your judgment, the reasons given for it are unsound. Instruction number 27. An expert witness has testified about his reliance upon books, treatises, articles, and statements that have not been admitted into evidence. Reference by the expert witness to this material is allowed so that the expert witness may tell you what he or she relied upon to form his or her opinions. You may not consider the material as evidence in this case. Rather, you may only consider the material to determine what weight, if any, you will give the expert's opinions. Instruction number 28. In determining the amount of losses, if any, suffered by the plaintiff as a result of the incidents in question, you will take into consideration the nature, extent, and duration of the injuries and/or damages you believe from the evidence plaintiff has sustained. And you will decide upon a sum of money sufficient to reasonably and fairly compensate plaintiff for the following items. 1. Plaintiff's loss of earnings from the date of the incidents to the present. 2. The physical and mental pain, suffering, anguish, and loss of enjoyment of life endured by the plaintiff from the date of incidents to the present. And 3. Damage to the plaintiff's property. Instruction number 29. No fixed standard exists for deciding the amount of pain and suffering damages, nor is the opinion of any witness required as to the amount of such reasonable compensation. You must use your judgment to decide upon a reasonable amount based on the evidence and your common sense. Instruction number 30. Whether any of these elements of damage have been proven by the evidence is for you to determine. Neither sympathy nor speculation is a proper basis for determining damages. However, absolute certainty as to the damages is not required. It is only required that plaintiff prove each item of damage by a preponderance of the evidence. Instruction number 31. If you decide that the plaintiff has proved that the defendants committed a trespass and/or a nuisance, plaintiff may recover damages that would reasonably compensate her for the annoyance and discomfort, including emotional distress or mental anguish caused by the injury to her peaceful enjoyment of the property that she occupied. Instruction number 32. Now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence as you understand it and remember it to be, and by the law as given to you in these instructions, and to return a verdict which, according to your reason and candid judgment, is just and proper. Will counsel stipulate that I have correctly instructed the jury?
Have your stipulation?
Yes, Your Honor, thank you.
Mr. Busby, you may now proceed with your closing arguments.
Thank you, Your Honor.